To be presenting some testimony, and it deals with an issue that Mr. Schmier was talking about earlier. We need to address separately. Is that correct?
That's my understanding, yes, Your Honor.
So you're going to be proffering some testimony?
Yes, sir.
All right. Who is the first person?
Aaliyah Garrett.
Can we have Miss Garrett come in, please? What is your full name?
Aaliyah Garrett.
Please proceed. It's a proffer.
It is, Your Honor, and I'm going to limit it to that issue.
Yes, ma'am. Yes, sir. Excuse me.
Ms. Garrett, do you recall an incident where you were talking to your friend Alexandria Chery via FaceTime when SANEL Saint Simon entered her room?
Yes.
And you're going to have to lean into that microphone. You're just soft-spoken.
Yes.
Where were you when this happened?
At Dana's house. At Dana's house.
And is that Dana St. Fleur?
Yes.
Was Dana on the phone with you at the same time?
Yes.
Do you remember whose phone it was?
It was Dana's phone.
Right? Now, you and Dana were on one end of the FaceTime conversation, is that right?
Yes.
And Alex Chery was on the other end?
Yes.
And FaceTime, when you FaceTime with someone on a phone, it allows you to see that person's face and or potentially the area within the scope of the camera of the other phone. Is that accurate?
Yes.
And you could see Miss Chery on the other end of that conversation, is that right?
Yes.
And do you know where she was?
Yes, she was at home.
And do you know that because you recognize the background?
Yes, I know her bedroom.
Okay. Do you remember approximately what time of day it was?
Like 3-ish, 4 o'clock.
Okay. Now, at some point, did you become aware that SANEL Saint Simon was outside Alex's room during that conversation?
Yes, because when she was inside the room, when we was on FaceTime with each other, she was like, oh, my dad's finna come bring me some money. Stay on the phone.
Okay. So she's speaking to you live in time about that. Is that right?
Yes.
What did you see or observe after she said that to you?
I couldn't really see anything because the phone looked like it was face down, kind of blacked out. So
okay. She put the phone down?
Yes.
All right. Did you hear anything when after the phone was placed down?
I couldn't really hear anything because it placed it down, so it kind of like staticky. Couldn't really hear anything until she came back.
I'm having a little trouble understanding. I think it's the microphone. You see the way mine is facing, ma'am? It's pointing right to me. That might. And then just talk with your mouth really close to the front of it.
And I apologize. I forgot to ask your question. After she said that her dad was going to give her some money, did she ask you to stay on the phone?
Yes.
And did she say why she wanted you to stay on the phone?
She was like, just stay on the phone because I'm scared.
Right. And then she put the phone down?
Yes.
Do you know how long it was between the time she put the phone down and when she came back and you could see her again?
Yes. It was like 10 to 15 seconds.
Was there a change? Well, what was Alex's demeanor like prior to her making the statement that her dad was going to give her money?
When she came back to the phone?
Before any of this started, when you were just talking on FaceTime, what was her demeanor like?
Aggravated, like, he finna come bring me some money.
Before that, when you were just having a normal conversation, what was her demeanor like?
Oh, we were having fun because we were finna go to Universal, so.
All right. And then when she stated that her dad was fixing to come in, she got aggravated?
Yes.
What was her demeanor like when she came back to the phone?
Angry, like she wanted to cry, mad. Okay.
And did she make any statements to you when she got back to the phone and you could see her face?
Yes.
What did she say?
She was like, he tried to touch me, he tried to touch me. She was gesturing to her boobs.
Okay. No further questions, Judge.
Any cross on the proffer?
Yes, Judge. Ms. Garrett, did Alexandria Chery say something like, I know he's coming, stay on the phone?
I'm sorry?
Did Ms. Chery say anything along the lines of, I know he's coming, referring to her stepdad, stay on the phone?
Yes, she was telling us, can we stay on, she didn't say stay on the phone because we were already on the phone with each other. She was stating, can you guys stay on the phone because my dad is finna come in the room to bring me some money.
How long had you been talking on FaceTime at that point? on that day?
It was like 30 minutes to an hour. We've been on the phone for a little minute because we were talking about going to Universal.
Did you ask Ms. Chery why she would put the phone down? Why she would put the phone down when her stepdad came in the room?
Because she was going to get the money.
I'm sorry?
Money.
Did she actually get up off, was she sitting on the bed? Was she lying down? Was she
Yes,
standing?
she was on the bed.
Okay. Did you ask her at any time, are you saying that she was scared before Mr. St. Simon came into the room, or as he came in the room?
So it wasn't, he didn't come in the room yet. When we was on FaceTime with each other, she was stating to us, my dad is finna to come give me some money, so can you guys stay on the phone? I was like, okay. And then the phone, she went away. Like, we couldn't see anything because she was going to get the money.
And you said that she was aggravated. Is that correct? Before she got the money?
No, we were happy. We were talking about going to Universal.
Well, I thought I quoted you saying that she was aggravated before she got the money.
No, she was stating like, my dad, like, you know, he'd be like, my dad finna come give me some money.
I'm sorry?
Like that. Like, I don't know how to explain that type of attitude.
Well, you couldn't hear what the male voice was saying. Is that correct?
Correct.
How long was there a conversation between the male voice and Miss Chery? I know you said you can't hear the specifics, but can you hear them talking?
I couldn't hear, but it was like 10 to 15 minutes because when she came, 10 to 15 seconds because when she came back to the phone, she was like, he tried to touch me, he tried to touch me.
When, in those 10 to 15 seconds, was there any shouting going on between Miss Chery and Mr. St. Simon, or just you can't tell?
We couldn't really tell because how she placed the phone down.
Okay. And then when she placed the phone down, how much time had gone by from the time the male, presumably Mr. St. Simon, entered the room till the time she began to talk to you again?
10 to 15 seconds.
So all you could hear her saying to the male is, get out of my room, something like that? Is that what he was saying?
So we couldn't hear anything because how she placed the phone down.
Well, after she put the phone down and began to talk to you, did she say anything to the male?
I'm sorry?
Did you say anything to the male, presumably Mr. St. Simon?
I couldn't hear anything because how she placed the phone down.
Miss Chery didn't tell you, well, you quoted her saying just, he tried to touch me. Is that correct?
Right.
She never said that he, in fact, did touch her. Is that correct?
I couldn't really state if he touched her or not because she didn't come to us exactly and say, oh, he touched my boob, but she was gesturing to us, he tried to touch me in a frightening way, in an angry, like, scary way. I know my friend Alex, so she's not the type of person who would just, he tried to touch me, no. So
when she said, he tried to touch me in a frightening way, what was your response?
I was just like, what's going on? Because we was happy. We was finna go to Universal. That just ruined our whole mood because we're like, what? Like, what? We couldn't think. Me and Dana was just like, what's going on? Besides
saying he tried to touch me, did Ms. Chery make any other comments about what supposedly had happened?
No, sir.
She didn't indicate that it was an apparent sexually motivated touching, like he had an erection, for instance? She didn't say that.
I'm sorry?
She didn't say that he had an erection. Is that correct?
I don't understand you.
An erection. Do you know what an erection is?
No.
When the penis gets erect.
Huh?
She didn't indicate that Mr. St. Simon was naked, for instance. Is that correct?
Correct.
She didn't indicate that she was naked. Is that correct?
Correct. But usually when she's in her room, so she don't be like pants with jacket.
Well, at that time of that day, it was 3-ish or 4-ish, you said, in the afternoon?
Because we were supposed to go to Universal that day.
So her clothes were still on. Is that correct?
Not correct. She was laying down in her bed.
I'm sorry?
She was laying down in her bed, so she had like a tank top and some shorts on.
Did she have a blanket over her or something?
No, she was just laying down.
Well, you don't know for a fact what is it, your testimony that she did not have any clothes on, or do you not remember?
She had on clothes, just not fully dressed clothes like how I have on now and how you have on. It's just clothes like indoor clothes.
Ms. Chery never indicated to you whether this alleged attempted touching was over the clothes or under the clothes. Isn't that a fact?
Correct.
And she didn't indicate to you whether or not there was a repeated other attempted touching
Correct.
in this incident. She didn't tell you how long the attempted touching lasted. Is that correct?
Correct.
So all she said was, he tried to touch me.
Correct.
You didn't tell her to call the police or tell her mom. Isn't that correct?
Correct.
In fact, you didn't even tell your mom either.
Judge, what is the relevance of this for purposes of the proper?
Judge, it goes toward whether or not the statement is trustworthy or not, if it's being offered as a spontaneous statement.
That's not an element of either of the exceptions the state is attempting to use.
It is an element if it's a spontaneous statement.
If it's a spontaneous statement and it was made at the time of the event or immediately thereafter, trustworthiness is an aspect of it, but those are elements that are considered based on the other. I'll let you ask the question, but you're doing a discovery deposition. This is a proffer, so let's move along.
There's nothing further.
Any redirect on the proffer?
No, Your Honor.
Okay. Ma'am, thank you very much. If you would step out, excuse me, step outside, please. You want to take the other proffer right away at the same time? Tell us your full name, spell your first name and last name, please.
Dana St. Fleur, DANA STFLEUR.
Thank you. Please proceed with the proffer.
Ms. St. Fleur, do you recall a specific incident involving your friend Alex Chery and SANEL Saint Simon where you were using FaceTime on your iPhone to speak to Alex Chery?
Yes.
And where were you during this phone conversation?
Home.
And that's at your house?
Yes.
Was anyone with you at your house?
Yes.
Do you know where Ms. Chery was on the other end of the conversation?
Yes.
How do you know where she was?
I can see through the FaceTime call.
And did you recognize the room behind her?
Yes.
What room was she in?
Her room.
Now, at some point during that conversation, did someone come to her door?
Yes.
And how do you know that?
Because there was a knock at the door and she told us.
Right, so you heard a knock?
Yes.
And what did Ms. Chery tell you, or what did she say when the knock was heard?
She put the phone down.
Okay, but a second ago you said that she told us. What did she tell you about the knock?
There was somebody at her door.
Did she identify who it was?
I'm not sure.
Okay. You said then she put the phone down, is that right?
Yes.
Right? Could you hear anything while the phone was down?
No.
At some point, did Ms. Chery respond or come back to the phone?
Yes.
Do you know how long it was that she was gone from when she put the phone down to when she picked it back up?
Like 10, 15 seconds.
Prior to the knock at the door, what was Alex Chery's demeanor like? In other words, what was her attitude like prior to the knock at the door?
Happy, just regular talking.
When she came back to the phone and picked it up, could you see her face?
Yes.
What was her demeanor like when she came back to the phone?
She was like angry and mad.
All right. Did she say anything to you when she came back to the phone?
Yes, she said that SANEL tried to touch her.
All right. Did she describe verbally or physically where he had tried to touch her?
She was pointing more at her chest, around her chest.
No further questions, Your Honor.
Cross.
Did you discuss this incident just now with Ms. Garrett?
Excuse me?
Did you discuss this incident now with Ms. Garrett?
No.
Today, you were telling us that Ms. Chery put the phone down she returned to you to report this alleged incident 10 to 15 seconds after she put the phone down. Is that correct?
Yes.
You recall giving a sworn police statement to an Orange County Sheriff's deputy back on July 28, 2014.
Yes.
And you gave that statement in a police vehicle in front of Ms. Chery's apartment. Is that correct?
Yes.
Have you read that statement recently?
No.
Do you recall what you said to Detective Garnett regarding how much time went by from the time Ms. Chery put the phone down till the time she came back to report this alleged touching? Do you recall that?
With who? I didn't hear.
Do you recall how much time you said had gone by from the time Ms. Chery put the phone down till the time she came back and reported this alleged touching.
Yes.
Do you recall you saying that it lasted like 3 minutes later?
No.
Would it refresh your memory to look at a copy of your statement?
Yes.
May I approach the witness?
You may.
Is that your sworn statement, Ms. St. Fleur?
Yes.
And in that statement, you were sworn to tell the truth by this detective, isn't that correct?
Yes.
Can you please turn the transcript over to, if you want to look at the entire statement and put it in context, once you turn to page 26,
Yes.
did you not, in fact, indicate to this detective that Ms. Chery came back about 3 minutes after putting the phone down and telling you what supposedly had happened?
Yes.
And isn't it a fact that in response to what you heard, both you and Ms. Garrett started laughing? Is that correct?
Yes.
Thank you. Nothing further.
Okay. Redirect.
Ms. St. Fleur, why would you laugh?
Let her get to this back from her.
I'm sorry. Thank you, Judge. Why would you laugh in response to Alexandria Chery saying that?
I'm not sure, but being when I was 16, I do laugh at a lot of stuff.
Now, when you said 3 minutes, did you mean, I just want to make sure I understand, from the time the phone went down until she came back, or the entire interaction?
Excuse me?
Yes, ma'am. So you described an interaction on FaceTime, right?
Yes.
That started presumably when Ms. Chery told you, or you heard a knock at the door,
Yes.
correct? And ended with her saying that Mr. St. Simon had attempted to touch her and describing her breast, right?
Yes.
When you responded to this question about how long she was gone in 2014 in your interview, did the 3 minutes mean the entire interaction or the time that she was gone from the phone?
Gone from the phone.
Okay. Thank you, Judge. No further questions.
Thank you. You provided the court and counsel a copy of the Hudson case, which the court has reviewed, and 2 other cases that were provided in this matter that I have read. Anything additional that you want the court to consider?
Just argument. So if you want argument, then
We are
What you're
at
asking?
that point, yes, sir.
okay. The other case I provided to Your Honor is MJ
Yes.
versus State,
Yes, sir.
and that's 994 7th 2nd 485.
Yes, sir, I read it.
Your Honor, I believe the statements that are described from the victim, Alexandria Chery, by the witnesses, Aaliyah Garrett and Dana St. Fleur, clearly fall within 90.803 sub 1 spontaneous statements. The MJ case lays out the requirements, but the statute or the rule itself make the requirements pretty clear. And it says a statement describing an event, I think it's contemporaneously, and I'm sorry, I don't have it in front of me. Pull it up. Or immediately thereafter. So the testimony from Ms. Garrett, Ms. Garrett is 10 to 15 seconds. The testimony from Ms. St. Fleur is 3 minutes. The cases that I saw where these statements were held to be not contemporaneous or immediately thereafter discussed 30 minutes or more. And that's as to 803 sub 1. Let me find, I also want to discuss the Hudson case because I also believe that they are an excited utterance under 90.803 sub 3.
I think it's sub 2.
Is it sub 2?
I believe so.
And the Hudson case discusses the requirements, number 1, regarding an event startling enough to cause nervous excitement. Number 2, before there was time to contrive or misrepresent. And number 3, while the person was under the stress or excitement caused by the event. The testimony from both witnesses indicate that there was a startling event, the attempt to touch, that there wasn't, particularly in Ms. Garrett's case, there was not time to contrive or misrepresent, and that Ms. Chery was still, by the way the manner in which it was described, the touching, was still under the excited influence of the event. So candidly with the court, I think it is more a spontaneous statement under sub 1 than an excited utterance, but I do think it fits both exceptions to the hearsay rule.
Okay, thank you. Mr. Schmier?
First of all, I'm going to renew the argument I made, which really wasn't addressed by the court because the court felt it was not right. But this is also a relevancy issue. If this were simply a battery, which would be an unconsented touching, I don't understand how a battery, even though it's not charged, would be admissible to prove presumably motive. That's why the state wants to get in this evidence. And I'll submit to you that if you believe these two girls, young ladies, as to what Ms. Chery recounted, at best, this would have been a battery, not a sexually motivated crime. I want to remind the court of two cases that I cited in our arguments the other day. One was Rosen versus State. The site is 940 Southern 2nd, 1155. That is a 5th DCA case out of 2006. In the Rosen case, just to reiterate what I said earlier, the 5th DCA affirmed 2 of 4, the Rosen case affirmed all of the convictions for lewd lascivious molestation on the part of a teacher who had abused students. The reason the convictions were affirmed was that normally a question of lewd lascivious intent is for the jury to decide. But there has to be enough of a factual basis to decide whether the jury can even consider that. In the Rosen case, there was enough evidence because the teacher not only touched, but he went way beyond that. He, in fact, rubbed the buttocks and breasts of certain students, and he did so with only after making sure that the classroom door was locked. He was the only teacher at that school who did that. You can jump to the reasonable inference that if you're a teacher and you go to the steps of locking a classroom door before you actually touch these students inappropriately, you'd have lewd lascivious intent. There's no such intent that can be inferred here. You have a girl who says to her friends, "He tried to touch me." But there's no evidence as to whether she was naked, how long the touching was, whether it was intentional, whether it was accidental, whether Mr. Saint Simon had an erection when he came in, whether he was sexually aroused, whether he made sexually inappropriate comments. There's none of that. All you have is in a vacuum is that he supposedly tried to touch me. The length of the touch is obviously probative on the issue of lewd lascivious intent. So I would direct the court to MLC versus State. This case I also brought up the other day. That case is 875 Southern 2nd, 810. This is a 2nd DCA case out of 2004. In that case, which involved a juvenile adjudication for delinquency, the 2nd DCA reversed 2 of 4 delinquency adjudications of lewd lascivious molestation behavior because the juvenile in that case, in those 2 cases, only had a split-second contact with these girls' buttocks. And the court ruled that as a matter of law, the split-second contact with these girls' buttocks precludes an adjudication for that offense because you cannot infer lewd and lascivious intent on the part of the juvenile and MLC under that fact pattern, which is very analogous to what we have here. You have a situation where somebody, obviously Mr. Saint Simon we were talking about, somebody supposedly had touched Ms. Chery, but you don't know how long, to what extent, whether comments were made or nothing. It's just, in a vacuum, this is not a sex crime. So on those grounds, I would argue that the evidence is not relevant on motive or anything else for that matter. On the issue of a spontaneous statement or excited utterance, spontaneous statement requires that the statement be made immediately at the time or immediately thereafter the incident. You can't have reflection before making that statement. It's certainly suspicious that Ms. Chery told, at least according to Ms. Garrett and Ms. St. Fleur, hold on, my dad's coming down, or my dad's coming in the room, just don't go anywhere. She put the phone down. That would almost suggest almost a setup type of a scenario if she is going to be doing that. There's no need to put the phone down and pretend surreptitiously that you're no longer on the phone. It just behooves credibility. Again, there was a 3-minute lapse, and I don't believe there's any testimony was shouting or in an agitated state as she was giving a description. Not that she gave one, because she just simply gestured to her chest. There's no evidence that this person was agitated when she made the statement. So it really can't be an excited utterance, because you have to be under the stress of the moment yourself agitated. If you're calm, that by nature is not going to be an excited utterance. I did indicate that Miss St. Fleur indicated that she and Miss Garrett were laughing. They were laughing when Miss Joseph Chery said this. The fact that they're laughing suggests that it's not a trustworthy statement, because they take it seriously, obviously. And that's why I mentioned that part, because the statute does say that unless it's untrustworthiness, the statement has to be made at or immediately after the incident. So I would argue that not only is it not relevant, it's just the hearsay exceptions are not met.
I have read the case law provided, all of the cases cited. I've heard the argument of counsel from the defense both the other day and today again. I have read over the various cases, as I said, involved, including the Hudson case, which is out of the Supreme Court. I have listened to the testimony of the individuals involved. The issues involve 803.1, which deals with spontaneous statement and excited utterance in this matter. With regard to Aaliyah Garrett, the court has considered the age of the declarant, which is the same for both of them, the physical and mental condition of the declarant in this matter, and the characteristics of the event, as well as the subject matter of the statements. Those are required to be considered by the court, and I've considered that with both of these individuals. The statements of the two young ladies, and these are young girls, are consistent except for the time frame involved. With regard to Ms. Garrett, the court finds that this is a spontaneous statement. It was perceived immediately after the event occurring, although almost spontaneous with it in this matter. I mean, only concurrent with it. The rule provides for immediately after. The court finds that there is no showing of any time to reflect, nor a basis to reflect on this matter, and the court is going to allow it to be admitted. She's talking about somebody trying to touch, as described by one of the witnesses, her boobs, by the other as her chest area, and pointing to those in this particular matter. So I am going to go ahead and find that. Also, the same with Dana Fleur. I'm a little concerned about the time frame being a little bit different from the former testimony, but based on the case law that I have read, whether it's 3 minutes or 10 to 15 seconds makes little difference in this matter. The substance matter of what is being observed, and considering the factors that I need to consider, suggests that these both are admissible matters in this, so I am going to allow it. We ready to go?